Appearances for the record, please.
Mr. Goodrich, Wayne County Prosecutor.
Dominic F. Andrew Jr., Your Honor, on behalf of Mr. Warner, who's seated to my right.
All right, and we're here for sentencing that's been adjourned a couple of times. All right, so Mr. Andriaki, have you had a chance to review the pre-sentence report with your client?
Yes, Your Honor.
All right, and you do have some, do you have any additions or corrections or just scoring challenges?
No additions or corrections. Scoring challenges, and I guess maybe it might be an addition or correction, potential issue with one of the victim impact statements. I don't know how you would classify that, but.
Okay, well, let's see. I received written victim impact statements from a minor, we'll just use initials for minors, is that all right? Minor PW.
Yes.
And I received one from Miss Barrison. That's one of the mothers. I received a letter from defendant's mother.
Correct.
And from his grandmother.
Correct.
So you're not talking about those two. Are you talking about the one from the adult victim impact statement?
Yes.
Okay. What do you want to say about that one?
Just that essentially the PW's mother is not a victim for these cases. She's not a complainant in either one of them. The complainant is PW. Because PW made her own statement and did not designate her mother to be making the statement on behalf, we would request that that statement be stricken. The adult statement be stricken.
Okay. Ms. Goodrich, your response to that?
Your Honor, technically by the statute, I would agree that because the victim wrote a statement, typically defense attorneys just allow the mother or the parent to also make a statement, but once the objection's made, then I don't really have a response to that because the victim did make a statement and stands by that.
Okay, so I will, obviously I read these when they come in, but I will disregard and strike anything in the written impact statement from the victim's mother and not consider any of those facts in the scoring of any guidelines.
Thank you, Your Honor.
Okay, so I do have the written statement from the minor victim.
Mm-hmm.
All right, and so why don't we go, we've got two charges. One, the accosting a minor for immoral purposes, which is scored at 5 to 23 months.
Mm-hmm.
And then using a computer to commit that crime scored at 10 to 23 months. So maybe why don't we take one objection at a time. So give me one scoring challenge and we'll
Sure.
go from there.
You want me to? We've had a little bit of discussion about these at the prior ones. I don't know how much you'd like me to go over those again.
I guess I'd like a refresher then.
Sure.
So what OV or PRV are you challenging first?
Of course, thank you, Your Honor. We're challenging OV4 and OV. Where is that other one? Forget the number of it, but it's the
OV10.
OV10, yes.
Okay. So let's do OV4 first. That's serious psychological injury to victim, and that was scored. Well, it wasn't scored in the accosting, but it was scored in the using a computer to commit a crime.
Correct, Your Honor.
Okay. And you believe that it should be scored at 0 points in both?
Correct, Your Honor.
And Ms. Goodrich, is your position that it should be scored at 10 points in both?
Yes.
Okay. So we're at all or nothing. And do you think that the argument applies to both charges, whether that should be scored or not? It should be uniform?
Well, I don't believe it should be uniform. I believe basically I would make one, given that the prosecution wants the 10 points for both charges, I'd make it just, I would state the argument, say it applies to both, but I believe that
even if it scored for the accosting, you think it maybe shouldn't score for the computer crime?
Correct, Your Honor.
Okay. All right. So why don't we take sort of level one of that is tell me why it shouldn't score why it should score for neither of them.
Okay, perfect. Thank you, Your Honor. So OV4 is a offense-specific crime or offense-specific OV, and that's according to People v. McGraw. So when we look at OV4, and I know in particular it's the victim impact statement, right? So when we look at the victim impact statement, the complainant or the victim, PW, states that she has started or continued counseling and has increased her medicine for anxiety or some sort of diagnoses based on family members blaming her for Mr. Warner being in jail. Now, because of McGraw, we have to look at what did Mr. Warner do, and did that necessarily necessitate some serious psychological harm needing treatment? According to the complainant's own, or the victim, again, I apologize, the victim's own statement, it's based on other people putting these pressures or saying these things, not that anything Mr. Warner specifically did. And for that reason, it should be scored at 0 for both of them. The additional argument would be there's no additional fact that because he used a cell phone to text the complainant, that use of a cell phone or use a computer to commit a crime.
So under McGraw,
Yes.
using a computer to commit a crime would not have resulted in serious psychological harm. So that even if it did score for the accosting, it shouldn't score for the computer. Is that your argument?
Yes, Your Honor. You've got it.
But that your broader argument is that even though the written impact statement would support that there has been serious psychological harm, that there's insufficient evidence on this record that has stemmed from the sentencing offense, that it has perhaps stemmed from post-sentencing offense conduct by people other than your client.
Correct, Your Honor.
Okay, Ms. Goodrich, what's the people's response to that?
Oh, Your Honor, I think that the being the victim of this offense had caused psychological harm, and being certainly a minor, difficult to explain, that but for his actions, she would not have to endure the consequences of coming forward and being honest and reporting him. This all stemmed from what he did to her that night, and I think that's just her explaining one of the things that happened as a result of that. She calls him a predator. He's come at her 3 times prior, and she says, I've had to go to counseling weekly. I'm on a higher antidepressant, and then says because certain family members have blamed me. So certainly that's all encompassing of what she's had to endure as a victim, which is typical of a victim. I think that the device that he used in order to commit that accosting was the computer. So, but for him not having a computer available that night, he would not have been able to accost her and cause that psychological injury. So I think that was a vessel to create that psychological injury. So I think it should be scored 10 points for both.
Right, thank you. Well, I think what the prosecutor has articulated about the sort of the dynamics of sexual offense against a minor and what they might typically experience and how that sort of flows into when other family members don't believe that victim and blaming them, that can compound the harm. I don't take issue with any of that factually at all as a general matter and even as a specific matter in this case. However, the case law on OB4 is, I guess, both broad and tight at the same time, or narrow at the same time. It's broad in that the amount of evidence needed to score for serious psychological injury is not a particularly onerous threshold to meet. But there are some limitations that it has to be victim specific. And there has to be specific evidence that that particular victim has suffered a serious psychological injury as a result of the sentencing offense conduct by the defendant. People v. McGraw, the Michigan Supreme Court has cautioned that we cannot consider post conduct that occurs after the sentencing offense is completed. Also, the case law cautions trial courts not to score OB4 based upon sort of these reasonable victim or what a minor would typically experience under this circumstance, as the prosecutors articulated. Again, I don't disagree with any of that as a factual matter, but as a legal matter, that would be insufficient. We did adjourn this sentencing to allow for even testimony if the people wanted to present that. What we have is a written impact statement. And upon reviewing that written impact statement, it only establishes that the minor victim has had to go to counseling and change medications because, and then she gives the reason for that, and it is other family members blaming her for Keegan being in jail. I think on this existing record, that is insufficient to find on a preponderance of the evidence that the sentencing offense conduct by the defendant caused the serious psychological injury to the minor victim. So I'll sustain that objection, and OB4 will be scored at 0 points on both counts. All right, Mr. Andriaki, as to OB10.
Yes, Your Honor.
It's scored presently at 15 points in both counts for predatory conduct.
Correct, Your Honor. And we would challenge that and believe it should be scored at 0 points. Primarily because there's nothing here to establish any kind of predatory conduct in specific to these offenses themselves. The using a computer to commit a crime. There's nothing that shows that this complainant was, again, this victim was predisposed to sending or receiving, inappropriate pictures by use of a cell phone or through Snapchat. And additionally, as far as the accosting goes, there is, on a lower level, at the 10-point level, there is a relationship between the victim and Mr. Warner. They are related. So there is that. However, there is no exploitation here in the respect that she was with another person, another juvenile, I believe at the time, and she refused to provide any kind of incriminating photos or anything of that sort. In fact, she turned around and reported the conduct, which is why Mr. Warner is here. And as the statute and the case law discuss, the mere presence alone is insufficient. So for those reasons, we would request that OV10 also be scored, especially for the using. The accosting is a little bit, I understand, a little bit tougher for Your Honor, given that, there is the 10-point difference there. However, especially when it comes to the cell phone portion, we believe it should be scored at 0. Thank you.
Can I ask you
Of course.
one question in my mind as I look at this with
Sure.
predatory conduct? That's defined as pre-offense conduct directed at a victim for the primary purpose of victimization.
Yes.
And the classic, situation for that is what's commonly referred to as grooming behaviors before the offense itself.
Sure.
And here, I'm not sure that there's a record of that until this offense occurred. With the major question in my mind, that your client has a previous juvenile adjudication for victimizing this same minor.
Mhm.
That is pre-offense conduct to this offense. And does that constitute predatory conduct that kind of bootstraps into this case at all? Or does the passage of time, does there need to be some sort of continuing sequence of events?
Yeah, that's a very good question, Your Honor. And I think just shooting from the hip here a little bit on that. I'm
thinking from the hip.
Yeah. I think the like you had just mentioned, if there was some sort of, especially with grooming, you notice some sort of, they befriend, they start doing these side jobs or whatever, and all of a sudden they're like a Boy Scout kind of thing where they establish this relationship, and then over the course of 6 months, 12 months, they start amping up the sexual misconduct, right? I think when we look at this factual record, yes, there is the prior conviction, but there's nothing to show what happened between the prior conviction and today. What's the grooming conduct that's the supposed predatory conduct that occurred to lead up to this moment, other than that prior offense. Maybe there was something there, but I think, as you had mentioned, again, we have to look at the preponderance of the evidence, of the facts. It's either come through a victim impact statement, testimony, through an actual oral statement, or perhaps something through a prelim or even a police report. We don't see that in this factual record. So I think that's a very good question. I think factually it could establish something to that effect. In this particular case, I don't see where the facts are there. So I would agree based on that. That's another.
And so you think that OV10 is properly scored at 0, not even the 10 points, because there's no exploitation. So if the accosting is sort of the soliciting or sending of something,
Yes.
that then by your reasoning, that would never support, or on those facts would not support the exploitation of a vulnerable victim. I mean, there's plenty of times where accosting is pled down from other behavior, but if the accosting is truly the sort of soliciting, the without invitation, sharing inappropriate messages or pictures, and the solicitation of them to reciprocate, that conduct itself does not amount to manipulation for selfish purposes to constitute the exploitation. Am I understanding that right?
Yes, I think, in other words, I think there has to be an additional fact. So let's say, for example, let's get into a little bit of a hypotheticals. I think that might be helpful. I think if there's something, there's predatory conduct where a person goes out and, they case a playground, or they know that the parents aren't there, or they already have some sort of cell phone, and they choose one family member as opposed to a second family member. That, I think there's a little different factual scenario there, where there is something over and above just the mere relationship or the age itself. Let's say, for example, there's a bunch of children at the playground, and a defendant chooses one out of that group of 5 kids because there's a younger person watching them, and there's nobody, the parents leave or something. I think that sort of circumstance, definitely predatory conduct. Even there's 2 siblings back to back, they choose one because one of the younger siblings has something in their background, maybe a learning disability or something, that they could manipulate to their own gain. I think in those sort of circumstances, an accosting would support points even under OV10 for predatory conduct, or even the youth agedness and so forth. In this circumstance, I don't see, there's nothing to kind of give more, I guess, context, as the way I would kind of look at it, as to that.
What about, I have one more question for you before we hear from the prosecution. And this is back to predatory conduct, pre-offense conduct. Why can't I parse out the messages so that the messages, as it begins in the offense narrative, there's this message back and forth, what are you, he's reaching out, what are you doing? And then he's talking about his mood. He's talking about, he's making some references to, I guess he's sort of leading up to that he's got some sexual urges. Before he's asking her to be engaged with any of that, he's sort of leading the conversation in that direction.
Sure.
Why wouldn't that constitute the pre-offense conduct before the act? Because that's not criminal at that point. So then once there's the criminal event in the conversation, can I count the previous leading up to that moment as pre-offense conduct directed toward victimization?
I don't believe so, because I think it's all part of the same transaction or occurrence, so to speak. I'm trying to think when we see like the Chris Hansen kind of things.
They're doing some things on it, because I've scored it in those cases. I've had a couple of
Yeah.
those sting operation cases, and
Mhm.
they stop along the way and they get some things, or they communicate with them several different times.
Mhm.
So it's more than one conversation.
Yes. I think in that circumstance, yeah, arguably OV10 can get scored that way. I think in this one, especially too, one of the other factors here is she says, if I'm not mistaken, that she's with somebody else at the same time that he's sending these messages to her. And there's not it's not really even a back and forth. It's just he's stating these things to her and she's pretty much not reciprocating.
Okay. All right. Thank you. I think I understand your position. Ms. Goodrich, what's your
Thank you, Your
response?
Honor.
Thank you, Your Honor. I would ask that the court consider the case, 2003 case, People versus Witherspoon, 257 Mishap, 329. In that case, the defendant, it was an in-person assault case, but the defendant had waited to no other person was present. There was waited till the child was in the seclusion of a basement and watched the child and waited for her to be alone before the assault. So the defendant in this case is going to use a phone to commit the accosting. So what does he do? He uses the fact that he's a relative, that they have this previous relationship. She has been previously a victim of his actions. He knows her. He knows how to manipulate her. He waits till she's at a friend's house. He waits there. There's no parent around. There's no other adults around. It's just only her and another juvenile friend. He then has the setting in any location. No, it's the location of the bedroom that she has at her grandmother's house. So he's in her bedroom when he's texting her and doing this accosting. He's laying in her bed to get her attention, to get her to engage in the conversation. He initially sends innocent texts to start getting her to talk to him before switching into the sexual conversation and sending the sexual pictures. These were all previously, I believe, contemplated pre-offense conduct and grooming her into getting her led into this situation. And so I think that the exploitation is properly scored at 15 points.
Thank you. Any rebuttal argument to that?
Not primarily, Your Honor. Again, I think we've discussed it. I wouldn't say anything additional. Thank you, Your Honor.
All right. This is presents an interesting question. The statute, the statutory sentencing guidelines for offense variable 10 are for exploitation of a vulnerable victim. And it's been scored by the Department of Corrections at 15 points for predatory conduct being involved. Predatory conduct is defined as pre-offense conduct directed at a victim for the primary purpose of victimization. And here, the prosecutor, I guess I'm persuaded by the prosecutor's argument presented here today that there were a series of choices and decisions and actions that the defendant made leading up to the criminal exchange on the text, with his placement of where he was, the exploiting that relationship, waiting until the victim was at outside of the her parents and her home, and then some of the messages leading up to the criminal parts. So I think that all of that is pre-sentencing offense conduct. It does involve a series of choices, decisions, and actions. They are directed toward this victim for the primary purpose of victimizing her with the accosting by the computer, which he did. So I think the prosecutor has laid out some pre-offense conduct that would support that score by preponderance of the evidence. So I'll leave OV10 scored at 15 points for both counts. So I've sustained the challenge to OV4 in the computer crime. So that would lower that from total OV 30 points to 20 points. So that would then be to the D grid here. That would be from OB level 3 to OB level 2. And that would then be, instead of 10 to 23, it'd be 5 to 23. Is my math correct, Mr. Andracki?
I believe so, yes, Your Honor.
Ms. Goodrich?
Yes.
All right, any other scoring challenges from the defense?
No, it was just OB 410, thank you.
Any scoring challenges from the people?
No, Your Honor, thank you.
Okay, Mr. Andriaki, any allocution you want to make on behalf of your client?
Yes, thank you, Your Honor. I think when we consider this case and Mr. Warner as a whole, unfortunately, there's a significant amount of substance abuse history for him. If you give me just 1 second, I apologize, Your
Sure.
Honor.
I'm sorry, before we get rolling on that, can you help me calculate what jail credit he's allowed as to today? I think I had calculated 239 days back to the October 21st day that we were at. Has anybody done the math to see what credit he's entitled to today?
I have not.
Okay,
I have that now.
so let's establish that before we get rolling on the next part here. So up through January 28th would have been 189 days. So now we've got from January 28th to November 25th. Rather than look at the calendar, why don't I just grab a date calculator? What I'm going to do is I'm just going to put in the start date at the February 10th, 2025. And oh shoot, that is not right. And I have to put the days in. I don't get 2 dates. Oh, start date and target date. Here we go. All right, I'm using the Michigan Court of Appeals date calculator with a start date of February 10th, 2025, and a target date of today, 11/25/2025. And that says 288 days. Any objection to using that for the credit days?
No, Your Honor, that's consistent with the jail list today.
Oh,
No objection, Your Honor.
oh man, I wish I would have just asked you that. I would have, at least I didn't have to do math. All right. All right, I'm sorry. Mr. Andraki, go ahead with any allocution.
Thank you, Your Honor. When we look at Mr. Warner's, obviously, being sentenced on a using computer to commit a crime and a cost of the child for moral purposes, obviously, they're not great crimes to be sentenced on, right? We all understand that the name of them, the conduct that predates them, that leads up to them, the sex offender registration, everything that goes into that. Mr. Warner's going to be living with this for the rest of his life, including with the registration. The primary thing here, when I look at his, first, the letters that were in support, and second, when I look at his adult history or even juvenile history in a PSIR, Mr. Warner does not have a significant incarceration period from what I'm looking at here. He does have family members in support. I do believe that with 5 to 23 and 2 to 17 on the accosting, you know, it comes down to.
I've got 5 to 23 on them both.
I scored the accosting at 2 to 17.
I think that was if you won on OB10.
Maybe I misscored it. So it's class F. And looking at the PRVs are 35, the OVs
Or 20.
Oh, you're correct. Yeah, OV 35 and 20. So let's go to class F 35 and 20. Yeah, you're correct. I apologize, Your Honor. It is 5 to 23.
Okay,
Sorry about that.
that's fine. That's fine.
You know, it comes down to a prison sentence or a jail sentence at 5 to 23. And I would note, yes, that there has been a previous conviction involving this complainant previously, this victim previously. Mr. Warner, unfortunately, he's a young man, 21, 22 years old, has racked up a significant criminal history. We would request a jail sentence be imposed primarily because all the factors in here have been considered previously. So the fact that he's previously had a case involving this complainant is included in his PRV scoring. The facts of the circumstances of the actual conduct here is scored in the OVs. He does have family members in support that will do whatever they can to try to help him stay on the straight and narrow. I do believe that, again, he doesn't have a significant incarceration history. 12 months in the county jail would obviously teach him a lesson on these. With all that considered, and I do believe probation and oversight would be appropriate for him too, given the substance abuse problems that he has. Essentially, this case comes down to a substance abuse issue. He does have, when we read through there, he was intoxicated and sent these messages should have never sent. So for all of that considered, Your Honor, we would request a jail sentence of 12 months in the county jail.
All right, thank you. Mr. Warner, it's not required that you don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
I just want to say I regret what I did. I was going through a really rough time and I used my phone to do something I shouldn't have done, and I should have thought it through and not did it.
Okay, thank you, sir. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 22 years old with 1 felony and 1 misdemeanor and a juvenile record. He's unemployed with an 11th grade education. What the guidelines don't take in consideration is that he has re-victimized a previous victim. The guidelines don't take in consideration that he was on probation for the same offense when he committed this accosting, all at only 22 years old. He has quite the history. The family member support that we're discussing is the same family members that are giving the victim a hard time, making her feel awful for telling the truth and coming forward. I would ask that the court sentence him on top of the guideline range at 23 months.
All right, thank you. All right, after this sentencing offense, he committed a similar offense for which he's on probation, correct?
Yes, Your Honor.
Oh, okay, so he wasn't
I
on
had that
probation at
backwards,
the
I
time of this
apologize.
offense, but subsequent, which is relevant factor. Okay.
Thank you.
All right, Mr. Warner, if you please stand for the court sentence. All right. Mr. Warner's 22 years old. He's got a prior felony, 1 misdemeanor, and juvenile history. He's here for sentencing on the offenses of accosting a minor for immoral purposes, for sending inappropriate messages and photographs to her and asking her to do the same, and using a computer to commit that crime. The advisory guidelines are scored at 5 to 23 months on both counts. There is discretionary consecutive sentencing that's authorized by the computer crime statute. In this case, Mr. Warner's history is what's most concerning. He has a juvenile adjudication for accosting and indecent exposure in 2016 involving the same victim as in this case when she was 7 years old. And now as a teenager, he's victimizing her a second time. And then also after this offense, the offense date for this case was October of 2024. In March of 2025, Mr. Warner engaged in similar conduct in Emmett County. A different victim, still related to him, and about 12 years old. And he's been sentenced to probation with a jail term. I think the prosecutor makes a good point that the guidelines, although they take into account the prior or subsequent convictions, they don't take into account the disturbing pattern here of similar sexual crimes, now 3 of them. They don't take into account that he's victimized more than 1 victim. And they certainly don't take into account that he has now victimized the victim in this case for the second time. Once when she's 7 and then when she's a teenager. This shows that this is beyond an alcohol problem for Mr. Warner, that he has a serious issue with being a predatory sex offender, victimizing minors that are related to him, more than 1 and more than 2 victims and one of them victimized twice that we know of. There'd be a pretty good argument that those factors aren't taken into account in the guidelines and there'd be grounds for an upward departure. But given that he's got no prior record, that these offenses didn't involve actual contact with them, I'm not sure that, that I'd want to do a departure sentence. I certainly do agree with the prosecutor that I think upper end is a proportionate sentence here. So that there's $136 in state cost, $130 in a crime victims assessment, $350 in court costs. Mr. Warner has been registered with the Sex Offender Registration Act. He has to comply with that. And on the charge of accosting minor for immoral purposes, I'm going to commit Mr. Warner to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 4 years, with credit for 288 days previously served. And for the use of a computer to commit a crime, I'm going to commit him to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 7 years. And I'm going to give him 0 days credit on that and exercise my discretion to impose consecutive sentencing. I think that strong medicine is required here, given his disturbing pattern of victimization, as I've outlined on the record. So that's the sentence of the court. Mr. Warner, you're allowed to, you may file an application for leave to appeal your conviction or my sentences or both. If you wanted a lawyer appointed to you, I would do that if you requested within 6 months of today's date. We're going to hand you a piece of paper explaining that appeal right and ask you to initial 1 copy for us. So we have a record, we gave it to you. The other one is for you to fill out if you wish to take an appeal. All right, good luck to you, sir. Thank you, Mr. Andre.
Thank you, Your Honor.
That concludes our docket. We'll be adjourned.